Supreme Court of the State of Colorado is now in session. Chief Justice Coates presiding.
Thank you. Please be seated. So we're going to have two cases now set on our afternoon docket. The first one of which is styled Deleon versus the People. Set this for an hour. Both counsel look ready. Counsel for petitioner, when you're ready, begin.
May it please the court, my name is Mark Evans, number 40156. I'm a public defender here today representing Mr. Deleon, and I will aim to reserve approximately 10 minutes for rebuttal. This case presents some interesting issues about the Fifth Amendment and the unique nature of no adverse inference instructions. But the reality is that this court doesn't need to reach them. The simplest rule, and the rule that's dispositive in this case, is that when a court unequivocally tells jurors that the only law they are to apply to the evidence in the case is the law contained in the final jury instructions, only the final jury instructions are effective statements of law. And that's already what our precedent establishes. Leonardo, and much more recently Johnson, establish a rebuttable presumption that jurors follow the instructions of the court. When jurors are told to only apply the final instructions and nothing in the record rebuts that command, we presume that jurors applied only the final instructions. But when a court makes an isolated comment about the law and then later in time tells jurors again and again to only apply those final instructions, any presumption regarding that initial comment has been rebutted. There's no reason to believe jurors applied it because the court expressly told them not to. This court and a whole line of Court of Appeals cases has already articulated those common sense principles, and they're dispositive here. Regardless of whether comments made to unsworn veneer members can ever be effective statements of law, and regardless of whether a no adverse inference instruction in particular can be effective when delivered only once by the court during voir dire, the fact remains that after the court made that isolated comment, jurors were repeatedly told to only apply the law in the final instructions. At the conclusion of trial, I will be giving jury instructions that you will be required to apply to the facts that you find. After all the evidence has been presented, I will instruct you orally and in writing concerning the law which is applicable to the case. All the evidence and law that you will have to decide the case will be presented to you as a group in court. And those are just examples.
Mr. Evans, let me jump in there. Good afternoon. You agree that the judge did an instruction with regard to the Fifth Amendment during the introductory phase, correct?
Your Honor, I agree. Well, I mean, the transcript is irrefutable. I mean, the court did bring up the topic before members of the veneer had even been called forward for questioning.
Right, and the only reason I want you to respond to the argument, because you kept saying that he said only apply those instructions, but he also said, I'm going to give you further introductory instructions. So he implied by saying further, so can you respond to, how do we draw that inference?
Right, Your Honor. So you're correct. After the jury was sworn in the afternoon, the next morning before opening statements, the court did say that it was going to have further introductory instructions and some additional introductory remarks. But even those comments on their face seem to imply a difference between introductory instructions and those which will actually be applicable to the case. And remember, just a page after the court said that, the court then emphasized, after all the evidence has been presented, I will instruct you orally and in writing concerning the law which is applicable to the case. So when you read that entire statement by the court in full leading up to the opening statements, what it indicates is that what the jurors are supposed to apply is what they're told at the end of the case.
All right, thank you.
And it's for that reason, I mean, those statements, for that reason alone, that the court's comment made before jury selection even really began, was not an effective statement of law. Jurors didn't have to apply it because they were told not to. Hence, the constitutional requirement in Carter and James was not met, and that's as far as this court has to go. Now, although this court doesn't have to, this case does present an opportunity to clarify when no adverse instructions must be provided, and I hope this court will take it. Of all the rights afforded to Americans accused of a crime, the Fifth Amendment's guarantee that no person shall be compelled in any criminal case to be a witness against himself is perhaps the most difficult to give actual meaning. And it is directly contrary to human nature. Outside of a courtroom, if I hear one person say that another person did something wrong and that person remains silent, I can't help but think somewhere in the back of my mind that if that other person was in the right, they would have piped up and said something. And it's no different in criminal trials. The human inclination to assume that silence in the face of accusation means guilt is so strong that courts presume that it occurs. Jurors give meaning to the Fifth Amendment privilege not because it's natural or because it's intuitive, but because our system of law demands it. That's why the amendment requires not only that the state be prohibited from actually compelling self-incrimination, but also that courts convey to jurors the demand that the right be given meaning. It's the Constitution itself that requires a criminal trial judge to give a no adverse inference jury instruction in an effective manner when requested by a defendant to do so. And for the reasons that I'm getting into here, the rule should be that if the defendant requests that instruction, it's constitutional error not to provide it in the final jury instructions.
Are you saying that's automatic reversible error if the court didn't? I recognize you think we shouldn't even get to this issue, but if we did, is it automatically reversible? Are there any circumstances in which the preliminary instructions like we have here would be enough?
Well, Your Honor, the rule being that it is constitutional error to not provide it in the final instructions leaves open the possibility that it could be proven harmless beyond a reasonable doubt.
Okay.
But in the end, the root problem is that I acknowledge that the Supreme Court cases on this don't say you have to provide it at a certain place. But if you provide it anywhere else, the likelihood is going to be that you've set that instruction on a different plane from all of the others that are provided.
Well, let's take the example hypothetical. The court gave I think you want to avoid the word instruction, but the court made comments like it did here. And then, in closing argument, the prosecution says, you'll recall the court told you in voir dire, you cannot assume adverse inference from the lack of testimony. Is that enough? I recognize argument of counsel is not an instruction, but counsel refers everybody back to that instruction. Would that be constitutional harmless error under your view?
Your Honor, assuming in your hypothetical that the standard first jury instruction is given, which indicates that these instructions are a complete embodiment of the law that you're applied to the case, then yes, that would be reversible error. I mean, of course I can think of circumstances where the court could leave out the instruction, realize the mistake, sit down and tell jurors, listen, I realize this isn't in the written instructions, but you need to know it's just as important as all the other ones. Of course, I mean, that may be harmless beyond a reasonable doubt. But in any circumstance where a court is telling jurors that the only law you're supposed to imply is what's in those final instructions, it's difficult for me to see how omitting it from there could be harmless beyond a reasonable doubt.
Can I ask you, where is the word only? I see the comments, I will be giving you jury instructions that you will be required to follow to apply the facts that you find. This was shortly after he gave the right to remain silent. And I'm not saying you're not being accurate, but what's the record cite for the words only?
So the words from the court do not use the word only. What they indicate is that the jury will be instructed on the law to be applied after the evidence has been presented. And if I could step away from counsel table for to counsel table for just a moment, I want to take a look at the jury instructions themselves.
Sure.
So the jury instructions themselves say, I will now instruct you on the law which you must apply in order to reach your verdict, which indicates that that is a complete statement of the law.
So do you think it's reasonable for jurors to think that since that other instruction wasn't included in there, that they could go against it? Even though the judge had said at the beginning of trial, you cannot hold it against the defendant if he doesn't testify. You think they could say, well, he didn't include it, so therefore it must be fair game?
Absolutely, Your Honor. I do believe that for a variety of different reasons. And there's ample precedent explaining why comments made to veneer members, if never again repeated by the court, can't be effective instructions of law. I mean, the purpose of voir dire is different. There's no legal basis to conclude that members of the veneer would be bound by preliminary instructions because they haven't bound themselves by taking any sort of oath at that point to follow the law. And on a more practical matter, I mean, you have to take into account that when that comment by the court was made, the court wasn't addressing jurors. It was addressing 60 people who knew, statistically speaking, that the odds of them serving on the jury were quite low, all sitting in the back of the courtroom, not the front of the courtroom where they'd be questioned, and all not knowing whether they were going to spend the next week of their life sitting in that courtroom or doing something else. I mean, I have no doubt the jurors in Colorado take their role very, very seriously, but the people the court was addressing weren't jurors. They were just 60 randomly selected citizens wondering whether they were going to be jurors.
Mr. Evans, I assume you're going to turn to the standard review. Can you talk about plain error versus constitutional harmless doubt, constitutional error?
Absolutely, Your Honor. So the plain error standard doesn't apply here because nothing that the district court said would have signaled to defense counsel that any sort of further objection was necessary. And the Court of Appeals opinion is based on this premise that the trial court said it would give the pattern no inference instruction, and I've reviewed the applicable portions of the transcript dozens of times now looking for what I missed, and for the life of me, I just don't see where that occurred.
I realize you may not have argued this at the Court of Appeals, but do you have any idea where that theory came from? Like, do you know if it was talked about at the Court of Appeals during oral argument?
Your Honor, I don't remember if it was talked about during argument. It was not asserted by the Attorney General in the briefing.
Right, no, I saw that.
Right. So no, I don't know what they're looking at in the record to reach that conclusion. But at the end of the day, counsel fulfilled longstanding preservation requirements by tendering that instruction and asking for it repeatedly. And the instruction was clearly rejected by the court. Neither the prosecution nor the defendant requested some sort of alternative instruction. And the court never said it was going to give an alternative instruction. So there was nothing for defense counsel to object to.
Well,
Didn't the court indicate it was planning to give the pattern instruction in lieu of the tendered instruction?
And, Your Honor, I respectfully agree. I just don't, and I realize you're the one asking the questions here, but I just don't see where the court said that in the transcript. I agree that the court may have illustrated a willingness to give the pattern instruction if somebody asked for it, but nobody asked for it.
I guess what Mr. Kozalewski would say, without meaning to put words in his mouth, but based on the briefing, is that there should have been a contemporaneous objection at the time of the actual giving the instructions because a light bulb should have gone off that, oh, the pattern instruction's not in there, and it's incumbent on defense counsel to then bring that to the court's attention. That's so, and they cite Hagos, which I don't think is factually on point, but they cite to Hagos for the proposition that there should have been a contemporaneous objection at that juncture. So can you respond to that argument? Hopefully I'm understanding it correctly.
Yeah, but Your Honor, everybody understood at that initial, immediately before the instructions were read, right? So there's a jury instruction conference on the FTR, and then it comes up again immediately before the instructions are read. And at that time, immediately before they were read, everybody understood that they were looking at a packet of 19 instructions. And this isn't a situation where the court said, I'm going to give 20, and then accidentally gave 19. everybody was talking about a no adverse inference instruction. They had the instructions right there in front of them. And there's nothing in the record to indicate at that time that there was an intention to give a pattern instruction. And it's also important to remember that in this context, the duty to give that instruction is only triggered by the defendant's request. So it's really difficult for me to figure out how you'd even frame a coherent objection to the court not doing something that you never asked it to do, that it doesn't have an obligation to do unless you asked it.
If we assume for a moment that the trial court judge meant to give the pattern instruction, that he was denying the request to give a different instruction, but he was going to give the pattern instruction, do you agree that the error then occurred when he failed to include it in this set of instructions?
Yes, I mean, if the court intended to give the instruction and didn't, then yes, that would be an independent error. And
there was no objection at that point or no request at that point that it be given, correct? Nobody said, Judge, you're missing the pattern instruction.
nobody said that you were missing the pattern instruction, but after the instructions were read and closing arguments were complete, the topic came up again. So this is all occurring.
Could you remind me, Mr. Evans, of the facts of that? So the judge read the instructions, and at that point, did defense counsel again register the objection about the instruction he or she wanted? I just can't remember the facts.
Yeah, Your Honor. So defense counsel had pulled from the Colorado Bar's website what I think were a draft of what ultimately became the 2016 version of the jury instructions. And during the initial jury instruction conference on the FTR and the follow-up immediately before the instructions were read, it became clear that counsel couldn't really identify where they got the instructions because the prosecution was pointing out, hey, this doesn't match the pattern instructions. And I think defense counsel is clearly flummoxed at that point. So after the instructions were read, counsel came back and said, hey, I did some research here, presumably while closing arguments were going on, and figured out that these actually came verbatim from the Colorado Bar's website as a draft of these amendments to the criminal jury instructions. But the point remains.
Did counsel just identifying where, I can't remember, was he or she found them, or did counsel say, we think you should have given it, or is there anything sounding like an objection after that? Is it just an explanation where the counsel found this draft, or did say, I still think you should have given this?
I think it's better read as an explanation to the court
Okay.
of, listen, I wasn't completely making this up. But the point of all of this is that in order to believe that the court intended to give that pattern instruction, but somehow inadvertently didn't give the pattern instruction, you have to assume that the court looked at this packet of 19 instructions immediately before they were read, then read the instruction, and then addressed the same instruction that we're talking about here after the fact, and at no point during that process realized that it did something or didn't do something that it was intending to do. And I think the court didn't say that because it was never intending to give the pattern instruction. I mean, of course, I don't know what the court was actually thinking, but this notion that defense counsel should have objected again really seems to be based on the idea that the court clearly indicated that it was going to go down some other route.
I guess I'm sorry, go ahead and finish your thought.
No, Your Honor, and I mean, regardless of what the court ultimately intended, what the record doesn't show is any clear expression that I'm going to do this other thing for you that would thus obligate you to object when it doesn't happen.
From your perspective, is it enough that defense counsel tendered an alternative instruction addressing the very topic that there's now a question about?
Yes, Your Honor. I mean,
It seems to me that's much more straightforward than what we were just talking about, right? So,
Right.
all right, and Is there any case law that addresses that specifically, where just tendering an alternative instruction on the same topic that arguably even constituted a correct statement of the law, why that shouldn't suffice for preservation purposes?
So I'm not aware of any Colorado cases to that effect. I mean, the rule seems pretty clear in Colorado that if you tender an instruction, you have preserved failure to give that instruction for appellate review. There are some federal or out-of-state cases where there were really fact-specific intricacies where, for instance, the defendant would tender an instruction before trial, and then by the time we get to the end of trial at the jury instruction conference, the court says something like, hey, I'm just going to give all of the same instructions that were given at your previous trial that ended in a mistrial, and counsel says, yes, that's fine. Or, it's tendered in a packet of instructions given by the opposing party, and nobody ever addresses the issue. But I'm not aware of anything coming remotely close to saying that you can tender an instruction and ask for it twice, and then have that not be preserved for review.
All right, so did you want to, anybody else? I know you want to try to save 10, but can you quickly just address the strength of evidence issue with respect to reversibility?
Absolutely, Your Honor. It's undisputed here that the alleged victim wanted Mr. Deleon out of her life. She viewed him as an impediment to her family, and that she made accusations against him shortly after learning that accusations of sexual assault can cause somebody to be removed from your life. Numerous witnesses familiar with the alleged victim from her own family came up and testified that she had a poor reputation for truthfulness. No physical evidence supported the allegations. And jurors struggled with this for a while. I mean, they were out for 2 half days and 1 full day, and we have no way of knowing what the jury credited and how much weight they gave to Mr. DeLeon's failure to testify.
So I want to come back to the questions that we were asking a moment ago, because I want to make sure that I understand your position. I'm looking at the Court of Appeals opinion, and maybe your position is that it's factually incorrect, but from what I'm reading, it says that before closing arguments, the court had the attorneys make a record of the instructions it intended to give the jurors. The court asked the attorneys whether they had any additions, corrections, or changes or objections, and defense counsel reiterated her request to give the jurors the instruction she had previously tendered on the defendant's right not to testify. The court again denied that request, saying, and this is a quote, "The better way to go would be to follow the pattern jury instructions." And then it says, when the trial resumed, the court read the instructions to the jurors. It seems that no one noticed that the instruction didn't include the pattern instruction or any other form of instruction on the defendant's right not to testify, because neither defense counsel nor the prosecutor alerted the court to the omission. Do you think is that accurate, or do you think that part of it is inaccurate?
Your Honor, I think it's a little out of context, because what the court said immediately before that line about the better way to go would be to give the pattern instruction was reiterating its position from the conference on the FTR. When the parties were in agreement, the court would occasionally use a Colgia instruction that both parties agreed to. However, that was not the case with any of these particular tendered instructions by the defense 1 through 5, which includes the instruction that we're talking about here.
But then it goes on to say, after reviewing those instructions, the court noted specifically those don't track the criminal pattern instructions, and the better way to go would be to follow the pattern instructions. Can we not infer from that the court, its basis for rejecting the tendered instruction was that it failed to follow the pattern instruction, and that it was inclined to give the pattern instruction instead?
I don't take that from
Okay.
that, Your Honor. I mean, I think that the court may have signaled its willingness to give the pattern instruction, but again, nobody asked for it. All the court clearly did on the record was say no to the instruction that was tendered. This court has no further questions. I'll reserve my remaining time for rebuttal.
Good afternoon. May it please the court. William Kozlowski, registration number 37824 on behalf of the people. I'll start with the plain error part, since that's sort of a factually intensive subject on this. And I think the Court of Appeals got it right. And the context of this is, if you read the FTR jury instruction conference, the defendant tendered 4 non-pattern instructions, 1 on the presumption of innocence, 1 on the charges are not evidence, the number of witnesses are not evidence, and the right not to testify. And if you read through from start to finish, the entire context of that discussion is these don't track the pattern instructions. And there was no dispute that there would be instructions on those subjects.
Where do you get that from? I mean, you're making an assumption. If the judge says, I reject your instruction, it's not pattern, I prefer pattern, period.
Well,
You read that, it seems to me to suggest that the court has now agreed to give the pattern, but doesn't someone have to ask for it?
okay. I guess 2 responses to that. My first response is he gave the other 3. He did. So his ruling was the same on all 4, but he gave the other 3. My second response is, and this is more, I'm not pointing to anything in the record. Of course he meant to give it. I think it is reasonable to think that a trial judge in this state, I mean, when I got this case, I didn't know, let's put it this way, I didn't know the rule was you had to ask for this to get it. I thought you would just get it.
But
This is
let
one
me
of those standard instructions that's just included, and that's how the parties dealt with it.
Let me flip it around. I mean, your argument is here the defendant didn't preserve the issue. Why is it on them? They asked for the instruction over and over, and the court said denied.
Okay.
Why is it waived? And didn't you admit, I think you argued in the Court of Appeals, did you not concede below the issue was preserved?
Yes, I did, and that was a product of, to be honest, I had not thought about it this way, that this was essentially two errors, that the first error is and I think if you go back and read the defendant's briefs, he made a big deal that his instruction was more correct than the pattern instruction. So the Court of Appeals said, no, the trial court was well within its discretion to say, the pattern instruction is better. And then I think the only reasonable inference from the transcript is that he intended to give the instruction.
And let's assume you're correct. Why does the defendant have to do any more than he did? He proposed an instruction, he tendered it in accordance with the rule, the court rejected it on the same point. Why is his argument not preserved for appeal?
Well, I guess that depends what argument you're saying he needs to preserve. And Mr. Evans keeps saying he didn't ask for it. Well, if the sequence of events is, I want this instruction, and the court says, no, this court hasn't approved it, so if I'm going to give anything, I'll give the pattern instruction. And then he says, nobody asked for it. Well, then we're in, he never even asked for it territory. So then there's no error at all. I'm not even making that argument. I mean, I think.
Can I turn that around slightly? I'm a little, I guess I'm still wondering, well, let me ask it this way. You're not suggesting that the tendered instruction was wrong, was an improper statement of the law?
I haven't looked at it in a while. I don't think there was anything incorrect in it, no.
I'm understanding, I didn't go compare them, but I'm understanding that this was basically the instruction that was adopted and is current. Is that not right?
I think there are a few differences, but I think the new instruction mentions that it's a constitutional right. I think that was the main difference.
Let me follow up then without necessarily answering that question. If the instruction was not an improper statement of the law, the tendered instruction, and the court refused to give it, I can see that if he gave something else, that might make it not be reversible error that he denied an instruction that was a proper statement of the law. But where he did not give anything in its place, why are we not simply addressing whether he erred by denying a correct statement of the law to which the defendant would be entitled?
Because I think that the error here is, I think the record is, I'm going to give the pattern instruction. That's the court's ruling.
Well, the first ruling is denied on your tendered instruction, right?
Right.
Okay.
And I don't think the defendant is challenging that ruling. So to me,
Well, it's hard for me to tell, because he does seem to be saying, doesn't he, that satisfactorily made the request for an instruction that's required by United States Supreme Court law.
okay, and my response to that is, and I think it wouldn't just come up in this situation. Let's say it's my position, it is what happened, that it was overlooked. So the question for this court is, do you need to contemporaneously object at that point? Do you need to notice that it's not there, essentially that the court is going against its prior ruling, and object? And I cited the Court of Appeals DiNapoli case on motions in limine. And there the case says, if you get a pretrial ruling on a motion in limine, and then it's violated, you can't just sit on your hands. You have to stand up and say, hey, you violated your previous ruling.
I guess, let me follow up just with the way I'm approaching this then, or at least asking a question. If the judge would be in error to deny an appropriate instruction unless he provided an equally appropriate instruction, that might be one thing. But if he would be in error to deny an appropriate instruction and then he does not provide an instruction to take its place, an equally appropriate instruction, why would there have to be an objection to his failure to provide something to make up for what would be error for him denying it in the first place?
It sounds a whole lot like, why isn't it on them, you know? And it seems to me to be very much like Justice Gabriel's question.
I guess my response is, it's on them and I cited Hagos just for the proposition of, we want this done properly the first time, and when the court says, I have 1 through 19 here, you need to go through 1 through 19 and make sure everything you have been told is in there is in there. And
But after he said, here's 1 through 19, at that point, the defense counsel said, the prosecutor said, I have no objections, and defense counsel said, well, I still object to your denial of my instruction number 2.
Well,
So he did say, I want that instruction, and it's not there. Why did he have to say, I want a different instruction that wasn't the one I asked for?
I mean, I just read the record as that the counsel's comment is, I think my instruction was better. I don't think there's any notion that the Carter instruction isn't going to be given. I think everybody just overlooked it.
But at the end of the day, it wasn't, and as Chief Justice Coates indicated, there was what seems to be a legally correct statement that was tendered, and I just for the life of me can't understand why that wouldn't be enough. But assume for the moment that you're stuck with constitutional harmless error review. Tell us how you win.
Okay? I mean, my first and best response is, how do we know that they did not make an inference of guilt from the defendant's failure to testify? And that is that they were told not to do that. And
When? I mean, is it not irrelevant? The only time they were told that was there are 60 prospective jurors out there, and the court starts by saying, well, I'm about to read you a few pages. It may sound like I'm reading a few pages. That may be because I'm going to be reading you a few pages. That's the only time the court said that.
well, that's obviously true, and I'm stuck with the record I have. But
Don't you hate when that happens?
I think, let me respond to it by responding to his argument a little bit. his proposed rule is great for us in every other case. If the court's rule is, if it wasn't said in the final instructions, it doesn't matter, then there are lots of cases that we can win with that rule of law, but I don't think that's realistic.
Yeah, I'm not sure with respect that he goes that far, and I think that rule is problematic myself. But when the instructions say you are required to follow the instructions I'm about to give you, don't we have to presume the jury follows the instructions?
Yes,
You all
but-
make that argument all the time.
Yes, but the leap that he is making is that they will do. Let me put it this way: the jury doesn't know the Carter instruction isn't there, and it's supposed to be there. So the leap is a juror sits down and says, "Oh, I'm going to infer guilt because he didn't testify," and then remembers the instruction and then says, "Well, he told us not to do that, but I'm thumbing through these instructions and that's not in there, so I'm going to do the opposite." I just don't think that's reasonable. As an example, I think a good example would be when a judge tells a jury, there will be objections, disregard them, whatever is said, disregard. Why do we do that? We tell them that because it's going to happen, and we know we want them to do the right thing when it happens. Let's say that's not in the final instructions. I don't think that's constitutionally required. We always put it in there, but let's say it's left out. Under his rule, the jurors would then say, well, I'm thumbing through these instructions. He didn't tell us again to disregard stuff that he sustained an objection, so I'm going to consider all that evidence. That's just not reasonable. Recently in Johnson, this court said, we presume that they follow all instructions, and that was a comment in voir dire. And there is no reason to think that they somehow disregard something that is said, particularly when it is discussed to such an extent during voir dire. And I think this is a practical argument of why my argument that it's effective, but even if it's not effective under the Constitution because the jury wasn't sworn yet, why it's harmless beyond a reasonable doubt. Defense attorneys use the court's introductory instruction to signal to jurors, essentially, my client isn't just, I think an attorney would say it if it was proper, just so you know, he's probably not going to testify. And there are a lot of reasons for that, and in this case, the jurors volunteered a lot of reasons why someone wouldn't do that, and then said, you're not allowed to infer anything from that.
Well, please.
No, go ahead.
No, go ahead.
So the way you describe the jurors flipping through the instructions and looking to see whether the Carter instruction is there, I agree with you. I don't think that would happen. But isn't part of why it's important to have the Carter instruction after this child has testified to horrible things and the man accused of the horrible things didn't say, no, that's not true, because the jurors, some of them acknowledged beforehand, their instinctive reaction to him not testifying is to feel that there's something important about that. And so to be reminded between that moment of instinctive, why is he not responding, and their deliberations, that they are not allowed to do that is important to prevent the jurors from doing what they, as human beings, will be inclined to do.
My answer to that is impliedly rejected by Supreme Court precedent, and that is from the Lakeside case. So the first case on all these subjects was the defendant argued, if I don't ask for this instruction, you can't give it because it unfairly highlights that I didn't testify. You can only give it if I ask for it. And the Supreme Court said, no, it can be given over your instruction. So, and this is the answer to your question. I think that is that's not an unreasonable concern, that giving the instruction will highlight that he didn't testify. So if a defense attorney, under that analysis, if a defense attorney says, I don't want to highlight this, but I want to give an instruction, so judge, would you please give it after the jury is sworn or after the prosecution rests or something like that, under that analysis that it has to be after the decision is made, then that attorney is being ineffective. That it cannot, if it can only be effective after it happens, then that takes that concern of, I don't want to highlight this to the jury too much, and says that concern is unfounded, and if you choose that path, that is ineffective.
My question was more just about the facts. My recollection is that this was a week-long trial finished on a Friday, is that right?
I guess I'll just go right, from voir dire to deliberations was a day and a half.
But then deliberations went,
Deliberations went on, yes.
basically another 48 hours, right?
Yes, that's true.
Okay. So it was a two-day trial, I'm sorry. That's
Yeah.
what I was trying to get at. So-
Yeah, from-
Right.
From opening statements, the testimony was a day, let's put it that way.
Okay. All right.
But the length of time between these introductory comments and verdict was Monday to Friday, is that not right?
I think that's probably correct.
Yeah, maybe that's where I was getting, thanks.
So if I can ask you, Mr. Kozlowski, help me with the rule you want us to adopt. I mean, how do we articulate what the standard is for constitutional harmless error under your rule? My fear is it sounds pretty vague when we can just ignore what the instructions say and just assume the jurors remembered what happened in voir dire. So help me with the rule we adopt that will cover the situation.
For harmless error?
Yeah, in this case, your argument is the jurors, they talked about it a lot in voir dire, this issue. They're going to remember it, even though the final instructions didn't include it. What's the rule? When do we get to consider what they talked about in voir dire, and when is it not enough?
Well, I think,
You look confused, and maybe I'm not
I guess I
articulating
was
well.
just saying I think all the cases on this are that it is definitely a case-by-case analysis of the circumstances, exactly what the judge said, the context of when he said it, the other things he or she said.
So help me understand what those factors are, and maybe I'll ask it the other way. Wouldn't it be a better rule to say we're going to presume the jurors follow the instructions, and when it says you have to follow the final instructions, that's the end of it?
But I guess that's, and Justice Boatwright pointed this out, and there's no instruction of only follow what I tell you at the end.
And the response from Mr. Evans, which I'd like to hear your response. Now I'm going to give you the instructions you must follow. You're making inference to us about what the judge said. Isn't the only inference from that is these are the instructions you must follow, period?
Okay, so whether it's, the effectiveness and the harmlessness kind of overlap, so I guess I'll just talk about it in that sense. The main thing to me is that, and I think a Carter instruction is, and I tried to set this forth in my brief, a Carter instruction is different than the other instructions. It's different than presumption of innocence. It's different than reasonable doubt. It's different than the burden of proof, because the jury always applies those in deciding the case. A Carter instruction is a prophylactic instruction, telling them not to do it. And my position is the best time to tell someone not to do something is before it happens. So it is unquestionable that you could not mention this at the beginning, not mention it in voir dire, not mention it at all. The jurors do what Justice Hart said, wow, why didn't he testify? An innocent person would have testified. And then at the end, they're told, don't infer anything from that. So it's the unringing the bell. In this case, to me, what happened is better. Up front, you're told, don't do this. And during the discussion, everyone says, yeah, there's a bunch of reasons why a defendant wouldn't testify. I can think of a bunch. It's a constitutional right. And so given the instruction, given the discussion, given the additional instructions after they were sworn, there's no reasonable possibility or view it as effective that they wouldn't do that. As I think Mr. Evans put it best in his brief, either they remembered it or they didn't. If they didn't, then it wasn't effective. I don't dispute that. If you read the record, oh, do you have a question?
Not yet.
Okay.
I'm about to, though.
Okay.
Well, I have one that's hopefully germane to this. Do you want to ask one first? Or?
Do you want me to referee?
Yeah, I'm trying to defer to my senior colleague here.
Let me take kind of a slightly different tack, maybe a version of what I think Justice Gabriel is trying to get at, perhaps. And that is, in terms of crafting a rule that would govern this case, I'm trying to discern when and under what circumstances a court's instructions, if you will, given during voir dire are sufficient when the court fails to give that instruction as part of the regular instructions at the end of the trial. So in that list of principles that the court walked through in its introductory comments, it included burden of proof and presumption of innocence and all of those, a whole host of things in addition to this no adverse inference and right not to testify. Is it your position that in some other case, the failure to instruct the jury on burden of proof or presumption of innocence would nonetheless be covered so long as the court made a comment to the veneer panel? When does it suffice?
Well, I think, and I think that's the line that I've tried to propose, that those instructions are very different in that the jury sits down and applies those in deliberations always. In a perfect world, the Carter instruction will never be looked at because the jurors will not do that already because they had been told before. Does that make sense? So to me, this is a very, it's a different instruction because it's prophylactic. It is not an affirmative instruction to do something. It is a don't do this, and we want to tell them that as soon as possible so they don't do it.
Well, and perhaps in line with what Justice Hart was suggesting, it seems it becomes more relevant at the time the defendant actually invokes his right not to testify.
Well, and I would just repeat my argument that may unduly, a defendant may think that unduly highlights that he didn't testify, and then that would take that decision out of his hands of when to ask for it.
Wasn't that decision made by the trial court here? I mean, do we have any evidence that the defendant asked for the introductory comment?
I don't dispute that he wanted it in the final instructions here, but I'm saying as a matter of constitutional procedural law, it doesn't have to occur after he makes the decision. And that's the, I have my list of cases here. That's the Castaneda case, I think it's a Ninth Circuit case, that it was only given after the jury was sworn in, was left out of the final instructions, and they said that that was sufficient.
So last question, I'll stop
Why I'm here.
monopolizing all of your time. Am I understanding you to be saying that there's no harmless error here, if that's the analysis we're applying, because this is a unique type of instruction that we want the jury to hear as soon as possible, but that the same, if the instruction that the court failed to give was one about presumption of innocence or burden of proof, an introductory comment might not salvage the failure to give that instruction at the end of trial?
That's correct.
Okay.
And to kind of add on to that, I'm not disputing here that there was a state law violation. He, whether it's plain error or preserved, it was obvious error not to put it in the final instructions, and that would be judged under the non-constitutional harmless error. The main issue here is, was there constitutional error? And my position is there wasn't at all, but if there was, then all the circumstances render that either harmless beyond reasonable doubt or not plain error.
Can I follow up with that?
Sure.
What do we do with the in Carter, the court said a trial judge has a powerful tool at his disposal to protect the constitutional privilege, and I'm skipping a line, and it says, No judge can prevent jurors from speculating about why a defendant stands mute in the face of a criminal accusation, but a judge can and must, if requested to do so, use the unique power of the jury instruction to reduce that speculation to a minimum. That's in effect saying if it's requested, the judge must give that, and it's to protect a constitutional privilege.
Right, and my argument is the instruction in voir dire satisfied that. I mean, that's my argument. And when you read Lakeside and then, the name escapes me now, the case after Carter, the court essentially says, we're not going to tell states how or when to give this
You're
instruction.
talking about James?
James, thank you.
So, my question was really about how your argument doesn't seem to even address strength of case. So, when you're talking about reversibility, you keep harping on whether or not whether the instruction at the outset satisfied Carter and James, and implicit in what you seem to be saying is that if that argument's not a winner, then you lose. But I don't think that's what you mean to say.
If which argument is
If you lose on the law, if we disagree with you about the oral admonition at the outset instruction, whatever you want to call it, being
Okay.
as effective, right? And
The-
I don't hear you making an alternative argument about how on these facts, it's still it's harmless beyond a reasonable doubt.
Okay.
Because.
I think if there is constitutional error here, it is purely procedural in the sense of we have two goalposts of when the trial is, and it starts when the jury is sworn and it ends with close it, whatever it be. And the instruction has to be in between those two goalposts. Here, it wasn't. So my argument would be it's harmless beyond a reasonable doubt because it was given right before that goalpost. There was an extensive instruction or extensive discussion of it. The instructions in the final instructions, Carter specifically rejected the state's argument that, hey, these other instructions cover it. Well, when you put the other instructions cover it when viewed through the lens of they were told not to make the adverse inference. So to me, when you read the final instructions, if you are aware of the Carter principle, those are read differently to include them. And that would be also harmless beyond a reasonable doubt. And finally, and this may answer your question, I'm not arguing that there's any sort of overwhelming evidence in this case. But I will say that if you read the trial, this case was essentially about, do they believe this child? And that was the only question, because if you believed her, he was guilty. If you didn't, beyond a reasonable doubt, he wasn't. And that everything was geared towards that.
Do you think a credibility case arguably places more of a spotlight on a defendant's failure to testify?
I don't think so. Well, maybe I'll answer the question this way. I don't think it puts it as much as, say, like an alibi case. I feel like those are the most susceptible to a Carter problem, where it's, hey, if you were somewhere else, you would have just gotten up and told us where you were and who you were with and called those people and told us where you were. But I don't dispute that there is a concern of, and it happens in every case, of, hey, if you didn't do it, get up and tell us you didn't do it. But I think that instruction in voir dire takes care of that concern. Carter is about, people assume this. They walk into the courthouse with this common sense of, I need to hear from both sides, and the defendant, if I was accused of something like that, I would speak up and say I didn't do it if I didn't do it. Well, one of the first things they heard and discussed extensively was, you're not allowed to do that.
So I have one quick question.
Sure.
Why is the discussion between the attorneys and the prospective jurors relevant to whether the instruction was effectively communicated?
Because it shows that they heard it and understood what it meant. I'm out of time. Thank you, Your Honors.
Buttle?
Justice Hood, you've asked several questions about the strength of the case and reversibility, and I agree wholeheartedly with the Attorney General that this case really boiled down to whether jurors believe the alleged victim. But that places it in the category of being a he said, she said, where he said nothing. And in that sort of circumstances, it could not have escaped jurors' attention that the one person in the entire world who could either confirm or refute the alleged victim's allegations was sitting right there in the courtroom and didn't say anything. That's why the instruction was so important, and it's why it was so important at the end of the case. The object of a no adverse inference instruction, the thing that it seeks to prevent jurors from speculating about, is the actual decision not to testify. And the effectiveness of such an instruction is severely diminished if it's delivered before that decision has been made and the right it seeks to protect has been exercised.
Can I jump in there? And I did this to Mr. Kozlowski, so I'll do it to you. Respond to James, a comment in James v. Kentucky, which is, the Constitution obliges the trial court to tell the jury in an effective manner not to draw the inference if the defendant so requests, but it does not afford the defendant the right to dictate, inconsistent with state practice, how the jury is to be told. So you don't dispute they were told at the very beginning. Respond to that in the James case. Why is that different?
Well, Your Honor, state practice, as reflected at least in our standard jury instructions, is that if the defendant requests a final instruction on this issue, they get it. I mean, the standard jury instruction book says this instruction must be provided. So that is state practice that we were seeking to conform with. Can the defendant dictate exactly when or where that occurs? No, he probably can't. But if the court's decision on when to give an instruction renders it ineffective, then constitutional error has been committed.
All right, thank you.
If that instruction is only provided at the very start of the process and then omitted from all of the other principles of constitutional law that are provided to jurors in the final instructions, jurors may believe that something changed, that something about the course of the trial indicates that they can consider the defendant's decision for some purpose without any sort of reiteration of that instruction after its object occurs. It's uniquely susceptible to not being honored by jurors.
Of course, that's premised on the notion that they remember the earlier admonition at all. And what Judge Welling emphasized in his dissent is that he wasn't confident that they would remember it.
Correct. And he certainly wasn't writing on a blank slate there. I mean, there are plenty of cases cited in the briefs that acknowledge that jurors may just not remember stuff that happened that far back. And it's not just about length of time, it's about situation too. Again, remember, and you can remember the last time you were called for jury duty, and they're all sitting in the back of the courtroom. This is very, very shortly after they walk into the room with the salutations and haven't been called up for questioning yet. This really wasn't real for most of these folks yet because they weren't jurors. They were just citizens.
Mr. Evans, let me ask you the same question I asked your opposing counsel. What's the relevance of the discussion that was had between the attorneys and the prospective jurors about the fact that the defendant has a right to not testify and that his choice to not testify cannot be held against him?
Your Honor, in a situation where the court unequivocally conveys to jurors that the only law that they're supposed to apply to the facts is the law contained in the final instructions, defense counsel and the prosecutor could have talked about the right not to testify from start to finish all through voir dire, and that doesn't make something other than the court's final instructions an instruction of law that the jurors have to apply.
The last question I have is, how much time went by between voir dire, when the judge gave the instruction that we've been talking about, and the discussion happened with the prospective jurors, and the beginning of deliberations?
So Monday morning was individual voir dire in chambers. Monday afternoon, the jurors enter the courtroom, and then the court's comment that we've been talking about occurs shortly after they enter. Voir dire extends the rest of that afternoon. Evidence is heard on Tuesday, and I believe on Wednesday as well. Jurors go out for deliberation Wednesday afternoon, and then return a verdict on Friday.
Got it, thank you.
If this court has no further questions, I'll conclude by saying that the Fifth Amendment privilege is critical to both the time-honored policy of separating ourselves from an inquisitorial system of justice, but also acknowledging the more practical reality that even a mediocre attorney can use cross-examination to obliterate the difference between how the guilty and the innocent present themselves to jurors at trial. But that privilege is not intuitive. It's not natural to folks. And if it's going to continue to protect all Americans, jurors have to be told in an effective manner that its invocation cannot prejudice an individual accused of a crime. That didn't happen here, and I respectfully ask this court to reverse the Court of Appeals.
Thank you. Appreciate the arguments of both counsel. Case will stand submitted, and the court will be in recess for 15 minutes.
All rise. Court is in recess until 2:17. court is in session.
Thank you. Please be seated. So the second case on our docket this afternoon is styled Centich v. VCG Holding Corporation. We've set this for an hour argument, but I see we've granted a motion with regard to oral argument. And just to make sure we all understand, so the way we're going to proceed on this is Ms. Newman for the plaintiffs will argue for 15 minutes. The respondents, or actually the defendants in this case, will then get 30 minutes to argue, and Mr. Siegelman will argue for the plaintiffs again, 15 minutes in rebuttal. Okay, I'm presuming you're Ms. Newman. Please introduce yourself and go ahead and begin your argument.
Thank you, Your Honor. Chief Justice Coates, may it please the court, counsel. I'm Mari Newman of Kilmer Lane and Newman, along with my colleague Leanna Orshan of Kilmer Lane and Newman and David Seligman of Towards Justice. We represent the plaintiffs in this case, a putative class or collective of exotic dancers who have brought legal claims in federal court based on federal wage and hour laws and state wage and hour laws. We've come to this court specifically to address a question of state law, and that is a question of contract law regarding the role of non-signatories to an arbitration agreement. And as the court is listening to this argument, I think three principles bear reminding. The first is that the purpose of contract law is to create certainty between the parties, certainty and predictability between those parties that contract. The second is that the United States Supreme Court has told us that contracts for arbitration are as enforceable, but not more enforceable than other contracts. And specifically, and Arthur Anderson told us, that we must look to state court principles to determine when a non-signatory may try to enforce an arbitration agreement. And the fact that arbitration is at play does not change traditional contract law principles. The third principle is that under Colorado law, which is the law we need to deal with, which is of course why we're here, the principle of equitable estoppel is a disfavored principle that is applied only under remarkable circumstances to prevent manifest injustice. It's not something that automatically applies, but rather it applies to protect those who cannot protect themselves, and that's why we're here. Equity, as the courts say, come to those who can't protect themselves. And with that in mind, we ask the court to hold that a non-signatory to an arbitration agreement cannot apply principles of equitable estoppel unless it meets the same traditional state law qualifications as any other kind of contract, which include detrimental reliance. Now I'm going to start talking about basic contract law. As the court is aware, basic contract law is designed to create predictability between the parties that contract. And that is, parties take on certain responsibilities in exchange for certain obligations. In this case, what we know is that the non-signatory corporate owners of these clubs chose not to be parties to the contract. They drafted the contracts and then gave them out to the different clubs across the country that used them, but chose themselves not to be signatories. We know that by looking at the contracts themselves, which are exhibits, examples of which are found at exhibits 1 and 4 of our opening brief. These define the parties specifically as the dancers and the individual clubs where they dance, but they make no reference whatsoever to the non-signatory corporate owners. And that's important because when we compare the 2014 contract and the 2015 contract, the 2014 contract, which is found at Exhibit 4, includes a provision which is taken out the next year. So the corporate owners chose to take even more distance from any kind of contractual obligations. And the specific point is on page 5. It's section 21B, where it initially in the 2014 version said that claims brought by dancers cannot be brought collectively against, not just against the club, but the club or any related person or entity. In the Exhibit 1, which is the next year's version of it, which includes an integration clause, it doesn't include that same language. So what we see is that those corporate non-signatory defendants have chosen not to take on any of the risks associated with being a contracted employer, and now they nonetheless seek to look upon the court for an equitable estoppel ruling that will allow it to strip the dancers of their rights to their day in court. And that's not what equity is all about. Now, of course, parties to a contract are not interchangeable. Just as because the dancers signed a contract with the club, these non-signatory owners can't enforce an arbitration agreement. If a dancer, for example, were assaulted by a patron, the patron wouldn't be subject to arbitration. They didn't sign an arbitration agreement. So that's a similar analogous situation. Likewise, if a patron were to slip and fall in a club because of some kind of a dangerous circumstance, the fact that there had been some sort of an arbitration contract between the clubs and the dancers obviously wouldn't bind the patron. Parties aren't interchangeable. Now, going back to the United States Supreme Court's position on this, the United States Supreme Court has made clear that contracts for arbitration are no more enforceable than any other. And more specifically, in the 2009 case of Arthur Anderson, the court looked at that with regard to the question we're seeing here, the obligations and the duties and rights of non-signatories to the contract. And what the court found in that case was that we looked to state law, but the fact that arbitration is at play does not change standard contract principles. Justice Hart, you
Ms.
seem to have a
Newman,
question.
yeah. Have we applied equitable estoppel in contract cases in Colorado? Let's ignore arbitration for just a second. How does equitable estoppel apply in the contract context?
You know, there's no case that is exactly on point, which is, of course, why we're here. But equitable estoppel has always been applied. And there are all kinds of cases, which we've cited in our brief, the Jefferson County versus Shorey, the V-Bar case, the Dove versus Delgado case. All of these cases are premised on the notion that equitable estoppel is only available when the person who is seeking to enforce the premise of equitable estoppel is ignorant as to the facts and has somehow relied to their detriment on the conduct of the other party. And these are general principles that are designed to be put into place in all kinds of contexts, which is exactly what the United States Supreme Court says we need to do here. Just because it's arbitration or a contract doesn't mean we look at it any differently than we would under any other sort of circumstance.
Ms. Newman, I know your time is limited. How do you want us to answer the question here?
Sure. Justice Boatwright, I appreciate that. The question we would like to have answered is that a non-signatory that seeks to enforce an arbitration agreement must first prove all of the traditional principles of equitable estoppel, including detrimental reliance.
And so we're not answering that question. We're just setting out the standard.
You're setting out the standard. That's exactly right, Your Honor. And specifically, the reason it comes up is because of the Court of Appeals erroneous decision in the case of Meister, which is the legal standard, I think, that the non-signatories would like this court to adopt. And I would submit to this court that Meister is wrongly decided for multiple reasons. Justice Marquez, did you have a question?
You were headed where I was headed, and that is, do you think then that we would need to overrule Meister?
I think that the cleanest and best way to do it would be to overrule Meister. I think that it is possible to more clearly define Meister, but I think Meister should be overruled for a couple of reasons. First, Meister does exactly what the United States Supreme Court says not to do in Arthur Anderson. It creates a different legal standard in the arbitral context, and that's exactly what Arthur Anderson in 2009 said we're not supposed to do. And Meister does that in reliance on some pre-Arthur Anderson cases and deviates strongly from what we're supposed to do. But there are a couple of reasons why Meister is problematic beyond that. The second one is that it's entirely unmoored from the equitable principles that underlie equitable estoppel in Colorado law. And that is because it's not about this question of manifest injustice, which is the core premise of why equitable estoppel exists. Thirdly, the interconnected doctrine that is proposed under Meister actually kind of seems to try to reinvigorate a principle that this court has already rejected. Justice Ide, in the Ingold case, rejected this notion of intertwined claims having to travel the same path. And the new version of that the Meister case seems to propose is this interconnected conduct between parties. Now, Ingold specifically dealt with intertwined claims, but it also expressly rejected the notion of intertwined parties having to travel the same path, referencing the Eagle Condominium Association case.
Can I ask you a question about that? Good afternoon. If, let's say hypothetically, a plaintiff sues, the dancers here sue the non-signatory for breach of contract, say it's an alter ego theory or something like that, would the arbitration clause apply then?
Justice Gabriel, I appreciate that question because that goes to the core of why these equitable principles should apply. That would be, as the Texas court said in the James Jody case, a party trying to have its contract and defeat it too. That is exactly what equitable estoppel is designed to guard against. A party that is on the one hand trying to use the contract as a sword and the shield. And Meister is sort of a perfect example of bad facts creating bad law. The plaintiff in Meister was on the one hand trying to get a ruling that was based on the contract itself while saying that somehow the arbitration provision of the contract shouldn't be applied. That is why bad law is created when a party tries to do something like that. So I think, Justice Gabriel, your question is exactly on point. Were the plaintiffs actually trying to enforce the contract, we would have a different question here.
And so it would apply, the arbitration clause would apply because the plaintiffs, if you're taking advantage of the contract, you're stuck with the whole contract.
I think that that's exactly right, Your
So
Honor.
could you address the argument from your friends across the aisle here? They say if you look at the complaint, and it's a fair statement, that all the defendants are sort of lumped together. No, I don't mean that in a disrespectful way. What do we make of that? I think there's a
Yes.
contract claim here.
Your Honor, I would say that you're conflating two different points, respectfully.
No, fair.
The plaintiffs don't seek to enforce any aspect of the contract. In fact, the plaintiffs forcefully repudiate every aspect of the contract. And in fact, the places where the contract is referenced in the amended complaint, I looked at it again this morning, are paragraphs, I think 90 and 91, where it says the defendants appear to understand what the Fair Labor Standards Act requires, but then do the exact opposite. That's essentially what those two paragraphs say. And so the plaintiffs are not trying to enforce the contract. What they're trying to enforce is the Fair Labor Standards Act and the Colorado Wage Claim Act and the state wage claim laws in the other states where the plaintiffs reside. Now, this is exactly the fourth problem with Meister. The fourth problem with Meister is that along with the interconnected test, it says that reference or note the existence of a contract. Now, if merely referencing or noting the existence of a contract is enough that a party somehow is bound by, that a party is able to take advantage of terms when it never signed it, a non-signatory is able to strip a signatory of their rights simply because they acknowledge the existence of a contract, that's a real problem. And the mischief that has sown is shown in all kinds of cases, including the Green versus Fishbone case, the Pollard case, where simply the existence of a contract was enough to strip a signatory of their rights vis-a-vis a non-signatory. And that's exactly what the problem is with Meister. So certainly if this court should overrule Meister is certainly where I come out on this. But if this court were to decide to clean up Meister or narrow Meister, certainly one of the things that needs to happen is some clarity on, it doesn't just simply have to acknowledge or refer to a contract. It has to actually seek to enforce the contract, as Justice Gabriel's question invokes. So, the purpose of contract law is, of course, to create fairness and predictability between parties, not between parties to a contract and somebody who chooses not to be a signatory after drafting the contract. The fact that it's an arbitration agreement doesn't change anything about that. And case law, which looked to a presumption in favor of arbitration to somehow modify traditional principles of Colorado contract law, are cases that need to be rejected by this court based on the Supreme Court's holding in Arthur Anderson. Manifest injustice is the only reason why this court historically has applied a principle of equitable estoppel, and that should not change. So specifically, we're asking that this court overrule Meister, but at a minimum radically narrow Meister and explain Meister such that any entity, certainly one that chooses not to be a signatory to a contract, cannot seek to enforce that same contract absent a showing of all of the factors that are required for equitable estoppel, including specifically detrimental reliance.
Let me follow up on Justice Gabriel's question. So some of the claims here are against signatories and some against non-signatories. Is there a concern that since they're all lumped together, to use the term that was used earlier, that we're going to have some claims being litigated in court, some claims being in arbitration, and risk perhaps ending with inconsistent results?
Justice Samore, that exact scenario has been addressed both by the United States Supreme Court in the Dean Witter case and by this court in the Ingold case. And Ingold actually relied on the Dean Witter opinion to find that exact concern of the potential of parallel proceedings leading to different results is not a justification to modify the terms of a contract. A contract needs to be interpreted according to the United States Supreme Court and to this Supreme Court based on the terms of who are the parties to the contract that are covered by arbitration and what are the claims in a contract that are subject to arbitration. So that exact issue has been addressed twice by the United States Supreme Court and by this court and rejected as any justification for interpreting an arbitration agreement beyond the four corners of the contract itself. With that, I see that I'm out of my time, and I'll save the rest for Mr. Seligman. Thank you.
May it please the court, Rudy Werner on behalf of the respondents, VCG Holding and Lowry Management. I want to start by following up on Justice Samore's question. Yes, there is a problem with inconsistent verdicts if the view of the petitioners or the rule the petitioners advocate for is adopted. And I think that even further than that, it's ultimately a question of, or a problem of issue preclusion. Because what will happen if, let's assume, plaintiffs are successful here, and then the claims against the signatory defendants are arbitrated, are subject to arbitration, and the claims against the non-signatory defendants, the respondents, are stayed pending that arbitration. And then let's assume the plaintiffs are successful in that arbitration. The arbitrator finds that the plaintiffs were misclassified as independent contractors, should have been classified as employees, awards damages, back wages, fines. Then, after the arbitration is complete, the stay is lifted in the district court, in the federal district court. Plaintiffs will certainly argue that issue preclusion applies and prevents the non-signatory defendants from relitigating the issue of liability under the FLSA or the Colorado Acts. And so what that will lead to is another round of litigation, another round of briefing, of argument, of opinion writing. And so ultimately, I think the problem of inconsistent verdicts is truly a problem of issue preclusion. And if plaintiffs intend, as they most likely will, intend to argue that issue preclusion applies if they're successful in the arbitration, then the question becomes, why not have the non-signatories be parties to that arbitration in the first place, if they're going to argue that they're bound by any judgment in that arbitration or award in that arbitration? So, yes, Your Honor.
With all due respect, does that come before us? I mean, we're tasked with a very specific question.
Yes.
So does that seems like that's for the judge to decide.
That is correct. However, this court is asked to identify those elements that must be proven in order for a non-signatory to compel a signatory, plaintiff signatory, to arbitrate claims brought against a non-signatory. And
So how would you answer that question? What do you want us to say?
So It is our position that the holding in Meister should be adopted by this court. Meister was not wrongly decided, as petitioners have argued. It is still good law after Arthur Anderson. In fact, it adheres perfectly to Arthur Anderson. The rule in Arthur Anderson, or the holding in that case, was that ordinary principles of state law applied to determine who is bound by an arbitration agreement, who is bound by a contract. Meister, Judge Miller in Meister, specifically referenced principles of state contract law in getting to the adoption of the rule that Meister ultimately adopts, which is the majority rule, as we have mentioned in our briefs. Judge Miller says that ordinary principles of state law apply to determine whether a non-signatory may be bound to an arbitration provision, and cites to the Smith case, Colorado Court of Appeals case from 2007. In Smith, the Court of Appeals held that a non-signatory could be bound to an arbitration provision, even though that the party didn't sign it. Okay, and then following Smith, Judge Miller cites to the Lane case from this court. Lane held that a third-party beneficiary under a contract, not a signatory to the contract, may enforce the arbitration provision against the plaintiff's signatory. So it's a natural evolution from those lines of cases to the rule that Meister adopts.
Except Meister doesn't ever talk about detrimental reliance, which is one of the settled elements of equitable estoppel.
It is, and it doesn't, because it adopted essentially a different rule than what petitioners are urging here, a different rule other than the traditional equitable estoppel.
So why should there be a special rule for arbitration agreements as opposed to treating an arbitration agreement like every other agreement?
Well, first, I would argue that arbitration agreements are being treated like other contracts, but this is a situation where the legal remedy is inadequate. The legal remedy that petitioners are urging the court to adopt here or adhere to here is that you have to be a signatory. It's a very formalistic rule. You have to be a signatory. You have to have signed that contract in order to enforce its arbitration.
Well, I don't think that's the argument at all. I mean, I gave the hypothetical to Ms. Newman. If they enforce the contract, they're stuck with that, against a non-signatory, if it's an alter ego or some other scenario. Let me flip this around. Here's my concern with your argument. In this case, the record would suggest that the non-signatories did everything possible to insulate themselves from contract liability, which is a perfectly acceptable business strategy. So how could they do everything possible to insulate themselves from the contract and then try to enforce the contract? It's the flip side of a plaintiff suing for breach of contract.
I think the focus here, Your Honor, the cases that we've cited in the brief and that Meister references say that the focus should be on the plaintiff's conduct here. The plaintiffs chose to sue both the signatories to the lease agreements and the non-signatories. They didn't have to sue
But they
VCG.
sued under statutory provisions. There's no breach of contract claim.
No, that's true. But they chose to sue both signatories and non-signatories. Those are related parties. They acknowledge that. And the claims in the complaint are, they allege this interconnected and concerted misconduct. This is the language of the rule that Meister has adopted. And courts have held, in fact, we've said that Meister is in the majority. In fact, it's in the overwhelming majority of states that have come to address this issue. 29 states, by our count, have adopted some version of the Meister rule, whereas only 5 states have agreed with the petitioner's rule that detrimental reliance is a necessary element here. And so, to get to the heart of your question, Justice Gabriel, it's not necessarily a rule that is different because it is, well, it is important that it's an arbitral context, but the more important point is that the legal remedy is inadequate. Or a rule that merely says you have to have signed the contract in order to be able to invoke its arbitration provision leads to untenable results. And I've already discussed those in response to Justice Samour's question. Those untenable results, the inconsistent verdicts, additional litigation over the question of issue preclusion, yes, not before this court, but the rule that Meister adopts would avoid those
But,
untenable results.
well, why wouldn't, and obviously I'm just playing devil's advocate with you a little bit here, why wouldn't a rule that says detrimental reliance required get you in the same place?
Because
That's the standard for deciding whether equitable estoppel should apply, or one of the elements.
Yeah. In the traditional equitable estoppel context,
Right.
that is true. It simply would never hardly get us to that same place because respondents like VCG, the non-signatories to the contract, would very rarely be able to prove detrimental reliance under the traditional view of equitable estoppel. And that brings me to kind of the question that I struggled with over this case, and which some of you may be scratching your heads about, is, are we really talking about traditional equitable estoppel here? And the answer to that is actually in Meister itself. Meister uses the term alternative estoppel theory. That, I think, is very important, and it's at the heart of this case. We're talking about a rule, a judge-made rule that has evolved in this arbitral context, which has supplied different elements that must be met in order for a non-signatory to enforce the arbitration agreement, and that those elements do not include the detrimental reliance element in traditional equitable estoppel. The Griggs case out of Maryland, Court of Appeals of Maryland, said this is a misnomer. This may be a misnomer because all of the courts that apply this rule, none of them require detrimental reliance to be proven. And so it may be, Justice Gabriel, to answer your question, that we're not really talking about traditional equitable estoppel, but we're talking about a rule that has developed, it has grown up as part of the natural evolution of the law in this area to address this problem of what do you do when both signatories and non-signatories to an arbitration agreement, when they're related, closely related parties, when they are sued on the exact same claims, when there is no differentiation between the signatories and the non-signatories in the complaint. Is it a more pragmatic approach to allow the non-signatories to compel arbitration in those circumstances?
I guess that begs the question of whether pragmatism, in a sense, gives us the right to rewrite the contract. I mean, I have a hard time escaping the notion that we're sort of engaging in this policy analysis to rewrite the contract. Why is that not the right way to look at it?
Well, I don't believe that you're actually rewriting the contract. There's many examples where, as we've already discussed, non-signatories are permitted to compel arbitration, such as the third-party beneficiary context. That's the Lane case. So rather than rewriting the contract, again, I think I've referenced this already, it doesn't comport with commercial reality for parent corporations like VCG and Lowry Management to sign every contract between one of their subsidiary clubs and their employees. GM doesn't, the parent company of GM doesn't sign every contract between one of its subsidiary windshield manufacturers and their employees. It just doesn't comport with commercial reality. And so courts confronting this problem of what do we do? Do we allow these two tracks, these two proceedings to go on, adopt a rule that says only the parties that have signed the contract may, in all circumstances, enforce the arbitration provision, or do we do something different? And I think Arthur Anderson actually has something very important to say on this. And the holding in Arthur Anderson was that it reversed the Sixth Circuit's holding that non-signatories to a contract may never enforce the arbitration provision. It was a categorical rule that the Sixth Circuit adopted, and Arthur Anderson said, no, you can't do that. It recognized that state law may allow a non-signatory to enforce a contract under various circumstances, alter ego, third-party beneficiary, and estoppel. It mentions estoppel. And so nothing in Meister, or the rule that we propose this court adopt, is contrary to Arthur Anderson's fundamental holding. In fact, I think it is perfectly aligned with it. It is up to this court to decide, this is the ultimate question before the court, whether detrimental reliance is a necessary element of estoppel in this area, in the specific context of arbitration.
Have we ever found equitable estoppel where there wasn't detrimental reliance?
I'm not aware of a case where this court has. But again, that would be under the traditional equitable estoppel.
Right, well,
that is
and
developed at
it
common
was,
law.
you were the ones who brought up equitable estoppel, right? I mean, the reason we're talking about equitable estoppel is because the defendants here said equitable estoppel is what will force the plaintiffs to arbitrate with
Correct.
non-signatories to a contract.
Correct, yeah. We moved to compel arbitration, the non-signatories did, arguing that the plaintiffs are estopped, equitably estopped, from avoiding that arbitration provision. And I think, again, the focus here should be on the plaintiff's conduct. The plaintiffs agreed to arbitrate claims. And the
With the other people who signed the contract. I mean, they entered into a contract specifically with the clubs, right?
They did, yes. And then when they brought suit against the clubs, the signatories to the contract, and the club's owners, VCG and Lowry Management, they alleged concerted misconduct. They alleged that both the clubs and the parent corporation intentionally misclassified them in these lease agreements as lessees or independent contractors, not as employees. And so I think the Machado case out of Massachusetts really is the best analysis of kind of the rationale behind this rule and why this rule has developed in the arbitral context and frankly, should be adopted, and it runs through the steps of and focuses again on plaintiff's conduct, plaintiff's choice in naming and describing the defendants collectively, not distinguishing between their conduct, and that's a choice by the plaintiffs and how they've pled their arguments. But
So
it's
it
also
sounds like you're trying to suggest that the plaintiff's choice in bringing their lawsuit is the bad conduct that would bring them into the world of equitable estoppel, but
yeah, no, it's not. It is not the bad conduct in the sense that we have relied on it to our detriment. It was a choice, a voluntary decision of the plaintiffs to do so, and rather than force the parties to go on this two-track system, one, the signatories going to arbitration and the non-signatories being subject to a stay, most likely, and then having to deal with what a stay is lifted. Plaintiffs, if they're successful in arbitration, they're going to argue that the non-signatories are prevented from relitigating those issues.
is it traditional that issues decided in arbitration can be used for preclusive purposes in litigation?
Yes, they may be. And so, that's the real concern here. What do we want to adopt a rule that encourages additional litigation after the arbitrator has issued his or her award? And I believe it is Justice Kavanaugh in the Sheen case, which identified that additional litigation and the burdens associated with that additional litigation of additional brief writing, argument, opinions, and then again inconsistent verdicts if issue preclusion does not apply. That would be a problem.
But you just said issue preclusion does apply.
Well, it would, but if the judge determined that issue preclusion for some reason did not apply, then you have the risk of inconsistent verdicts. But I think in our case, where the parties are closely related, they're in contractual privity, and it would be the same claims in the district court as were litigated in the arbitration, I think issue preclusion would apply. But
So then there wouldn't really be additional litigation about that, because if the parties are in privity and issue preclusion would apply, we just have settled questions.
We would, well, that's assuming the judge does find that issue preclusion applies. And this is just intended to illustrate kind of the dissatisfaction that many courts have felt with the minority view, and that is that when you have the opportunity to join both the signatory and the non-signatories under these certain circumstances where there's concerted misconduct and that misconduct is intertwined with the contractual language with the terms of the contract, then under those specific circumstances, pretty limited circumstances, then it is more, again, a pragmatic solution to the problem.
Should the scope of the arbitration clause itself affect our analysis, the language that's employed? I'm thinking specifically of the broad language arising out of this lease or out of the entertainer performing, et cetera. And that came to mind because of the supplemental authority citing, I think it's a First Circuit case that talks about the difference in different types of arbitration clauses.
I'm not sure, I don't think the language, specific language of the arbitration clause plays into this court's answering the certified question of law. You know, that's pretty clear. The court is only answering the question of what elements have to be proven. You know, I think it's a question that this court, frankly, it's not before this court. This court doesn't have jurisdiction over, but you know, arguably, the language, the broad language in the arbitration clause might encompass claims brought by the plaintiffs against both the signatories and the non-signatories. That's not the issue before us today, though.
But in answering the question, should we distinguish between the type of situation where, say, the plaintiffs sued non-signatories for breach of contract, and this type of situation where they sue not for breach of contract, but they bring a cause of action that, at least according to the magistrate judge, will require the decision maker to look at the contract, to interpret the contract, and you know, in other words, some of the provisions of the contract are gonna be in play. Is there a difference between those two?
I think there is, though the second point that you've made, I think, is an important one. But let's start with the first. If the plaintiff had sued the non-signatories for breach of contract, and this was discussed by Petitioner's Counsel, then it's the direct benefits test, I believe, under the Texas Supreme Court's decision that would apply, because plaintiffs are relying on the terms of the contract in order to allege their claim. They're not allowed to disavow the burdens, the arbitration clause. But the situation that is before us today is different, and in the situation in our case is different, and that is where there is this concerted misconduct. Plaintiffs have conceded in this litigation, or in the litigation in the district court, that they have alleged concerted misconduct between the signatories, the clubs, and the non-signatories. So the second point, or second part of your question, Your Honor, is whether that misconduct is intertwined with the terms of the lease agreement. And we contend that it is, because yes, the arbitrator will have to examine the lease agreement in order to determine the FLSA claim of improperly classifying the plaintiffs as independent contractors rather than employees. So the rule that we propose this court adopt, the rule in Meister, would give importance to the language in the contract in terms of the arbitrator or the decision maker's determination of whether the claims have been proven, the FLSA claims, because the test is not just interconnected and concerted misconduct, but whether that misconduct is intertwined with the terms of the contract. In our case, we alleged, or we argued that both of those elements of the test would be met. But back to the primary issue before this court, and that is what elements have to be proven in order for a non-signatory, for a non-signatory to compel the signatory to arbitration. And we submit that the holding in Meister and the rule adopted in Meister is the appropriate rule. Meister was not wrongly decided. Its reasoning is sound, and its holding should be adopted by this court in answer to the certified question. If there are no additional questions.
A couple of just cleanup questions. Is it your position that this unique rule for equitable estoppel that developed in the arbitration context was developed specifically to address these concerns around potential for inconsistent verdicts and the issue preclusion problem? Or
I think it was partly that. I think it was also partly a question of, and a focus on enforcing agreements where the plaintiff has agreed to arbitrate. The plaintiff here agreed to arbitrate all claims arising out of the relationship between the entertainers and at least the clubs. So
When you say at least the clubs, I'm sorry, but would you, thinking about Ms. Newman's hypotheticals, if there was a slip and fall at the club and the person who slipped alleged that it was because of distraction by the dancer, and he sued the dancer, would that, there's some, I can't remember the hypothetical perfectly, but if it wasn't this concerted action, as you say, could any non-party to the agreement be required, force the dancer to arbitrate because she signed an arbitration agreement with the club?
no, I don't think that hypothetical is applicable to our case or helpful in our case at all. We're simply a different situation.
But so you're saying there's a specific kind of non-signatory that can force her to arbitrate?
Not necessarily. It's when and this is the Meister Test, when the plaintiff has sued both a signatory and a related non-signatory. Many cases look at the relationship between the parties very closely. Meister did not do that, but many of the cases it cites do. So it's not necessarily one specific category of non-signatory, but it's a signatory that has been sued by the plaintiff, and when the plaintiff has alleged that concerted misconduct between the signatory defendant and the non-signatory, and when also that misconduct is intertwined with the terms of the agreement. And that's precisely the case here. Because as we just discussed, the arbitrator will have to refer to the lease agreements in order to determine whether the plaintiffs were misclassified under the FLSA. There's no question. And again, Machado from Massachusetts really, I think, has the best analysis on that point. So.
Last question, what do we make of the fact that in this case, it seems that the parent corporations went out of their way to make sure that they would not be part of these contracts, these lease agreements?
So I don't think that question really is before the court or necessary for the court to address to answer the certified question. But again, I think commercial reality in this day and age suggests that this is a very common practice, and the party that has the service relationship, here with the plaintiffs, is commonly the party that signs the employment agreement or the service agreement, not the parent corporation. So along with that, or in conjunction with that, the Petitioner's Counsel discussed the change between the 2014 lease and the 2015. That change had to do with, or was in the class action, collective action section of the lease agreement, not the arbitration provision. And so I think it's a stretch to argue that there was a clear intent by the parent corporations to try to disavow liability on one hand, but then come back in and attempt to enforce the arbitration clause. But importantly, that's not really for this court to decide. The facts of our case are, while a backdrop to this, to answering the certified question, the court doesn't have to weigh in on the specifics of the case that's before the federal district court in Colorado.
But doesn't this issue go to equitable estoppel and doing equity? If you choose, not to be a party of the contract and want to enforce it, that would seem to be, enforce the arbitration provision, that would seem to go to the equity issue here, and whether detrimental reliance should be required. So my question is whether, can we really avoid that question?
Well, I think the question is not whether you can avoid weighing in on whether detrimental reliance is at play here in the specific facts of this case. I think the question is whether it's a necessary element given all of the other facts at play here, given the fact that this is in the context of arbitration, given the fact that plaintiff has chosen to sue the signatories and a very closely related non-signatory. And as petitioner's counsel, I believe, alluded to, equity is a very flexible and fact-dependent doctrine. And we submit that it's within this court's power to, equitable powers, to adopt a rule that, or adopt the Meister rule, that addresses the specific problem that Meister and the 29 other states, in agreement with Meister, have been forced to address.
Thank you.
So hypothetical, if the plaintiffs in this case had sued non-signatories only, so there was no concerted conduct, and the lawsuit had nothing to do with the lease agreement, nothing at all, and it wouldn't require any interpretation of the contract or any anybody even reading the contract. Different result?
Different result, absolutely.
So in that case, it would not,
It couldn't.
they could not enforce the arbitration clause.
No question they could not. Okay,
Thanks.
thank you.
Wait, can I ask, so what if they sued only non-signatories, but on these same claims? What if they had just sued the parent companies?
Then, yes, I don't believe we would fall within the ambit of the Meister rule. Because it has to be that concerted misconduct, the interdependent and concerted misconduct between a signatory and a non-signatory. It's really that is the key to that test, is when the plaintiff has alleged that there's essentially this conspiracy, a conspiracy to misclassify the plaintiffs in this lease to the benefit of both defendants.
It does seem as a policy matter that this is sort of not really about equity, but instead about a preference for arbitration.
This is something that the courts have struggled with, and Arthur Anderson speaks to that, obviously. It says that the question of enforceability of a contract, of the arbitration contract, it must be answered by principles of state law, and the federal cases that referred to or relied on the federal common law of arbitrability, that those cases were, to the extent that they didn't also rely on state law, that they were wrongly decided or partially abrogated. But again, it's perfectly within the powers of the state's highest court to find that there is a rule that applies in this context. And whether you call it equitable estoppel, whether you call it an alternative theory of estoppel or estoppel in the arbitration context, I think that the rule has developed to address a situation that was commonly coming before the courts. And so, again, it's this natural evolution of the state contract law, which allows a third-party beneficiary to enforce a contract, an arbitration agreement that it has not signed, allows alter ego, and allows parties under the agency theory to enforce a contract that they haven't signed. So the next logical step in the evolution, according to the majority of the courts that have addressed this issue, is that non-signatories may allege that the plaintiffs are stopped from avoiding arbitration.
Mr. Werner, I'd say you're out of time, but actually it may be that we're out of time to ask you any more questions.
I'm grateful for that, Your Honor.
Okay. Okay, Mr. Seligman, and we even got the clock right on your 15 minutes here.
Great. Thank you very much. Good afternoon, Your Honors. Thank you very much for giving me and Ms. Newman the opportunity to split our time today. David Seligman from Towards Justice, also for the petitioners. In Arthur Anderson, the Supreme Court recognized a narrow exception to the rule, the general rule, that arbitration is a creature of consent between the parties. The exception arises from general, traditional principles of state common law that allows for non-signatories to benefit from or be bound by contracts. The question before you today is a pure question of state law. We should be clear of that. And in addressing that question, I submit that you should be less concerned with making your doctrine cohere with federal common law that has been abrogated and overruled, and more concerned with tying the doctrine to equity and ensuring that it doesn't cause any mischief across contract law in Colorado generally by allowing non-signatories to agreements to separate themselves from those agreements and then still benefit from them. The rule you announced today is constrained only by the principle that whatever it is, it cannot apply to arbitration agreements alone. It has to apply across contracts. And for that reason, I think it's especially important to be cautious about the rule that you announce. I'd like to point out that in my friend's argument, it's the overriding theory for why we should adopt a special rule for arbitration, which as an initial matter, I submit that the Supreme Court has already stated is inappropriate. But that the theory for why we should adopt that rule is because of some of these efficiency concerns. The problem of claims proceeding in two forums, piecemeal litigation. So a few things about that. First, this court and the Supreme Court have already said piecemeal litigation on its own is no reason to ignore contract law. It's no reason to create a rule specific for arbitration. If piecemeal litigation occurs, then piecemeal litigation occurs. We shouldn't bend our law to avoid it. Arbitration is a creature of contract and contract alone. These concerns about efficiency don't trump that. Secondly, and this court did, I think, a very helpful job of emphasizing this point in Ingold. My friend was very concerned about the possibility of either two claims proceeding at once or one claim proceeding in one forum and one claim proceeding in another forum. A key point that Ingold makes is that the district courts have tools to deal with these problems, and they use those tools all the time. So you can stay the case, right? You can wait to see what happens in arbitration. Those are discretionary procedural devices that district courts have to deal with these problems. That's the way that these problems should be dealt with, not by manipulating contract law, certainly when that contract law is going to apply not only in this case, but across cases. There's another point about my friend's argument that I'd like to correct, which is that the argument is made that in this case, and Justice Samore, you discussed this issue a little bit, that in this case, the court will necessarily have to look to the contract to resolve the issue before the court. That's not true. The claims arise under the statutory rights independent of the contract. And in fact, we know it's not true that the court in this case would not have to look at the contract in order to resolve the merits questions, because the same district court addressed a very similar case in Mason v. Fantasy Gentlemen's Club and never looked to the terms of the contract. The question in that case is, do the economic realities of the employment relationship suggest employee status and suggest that the workers are owed their minimum wages, entirely independent of the contracts before the court in that case. As for Meister, we, as Ms. Newman argued in her argument, we believe Meister is wrongly decided. It is true that Meister was decided after Arthur Anderson. It is also true that Meister identified that in theory the issue was one of state law. And it is also true that Meister relied in part on the Smith case, a prior Colorado case. But first, with respect to Smith, Smith itself was decided before Arthur Anderson, and Smith relied at its core on a presumption favoring arbitrability. We know now, and we know this from the 4 or 5 Court of Appeals cases that have addressed it head on, we know that the presumption in favor of arbitration does not apply unless and until a court has found that the parties to the agreement are bound by the arbitration provision. As Justice Gorsuch put it when he was on the 10th Circuit, before the heavy hand in favor of arbitration swings into play, there must be an agreement to arbitrate. Second, with respect to Meister, is that it relies on the quite full body of federal common law that had identified some new alternative, non-traditional, equitable estoppel theory, and it does so without once even referencing or referring to or citing any of this court's dozens of equitable estoppel cases that have arisen over the past century. I think to Justice Marquez's point, Justice Marquez, you asked whether this rule, this alternative estoppel doctrine, what was it, you asked what it was based on. Was it based on the sort of efficiency concerns, or is it based on equity? I think that there should be little doubt, and I think my friend had a hard time resisting this likelihood. There should be little doubt that it's based on, inappropriately based on these efficiency concerns and the purported liberal federal policy in favor of arbitration. So in discussing the rule in MS Dealer, which is the 11th Circuit case that gives rise to much of the federal common law preceding Arthur Anderson, MS Dealer says that the rule is in place because otherwise the arbitration proceedings between the two signatories would be rendered meaningless and the federal policy in favor of arbitration effectively thwarted. As for point A, we know that the possibility of piecemeal litigation doesn't matter here. This court has said that, and the U.S. Supreme Court has said that. With respect to the federal policy in favor of arbitration, we also know that that policy does not apply at this stage, meaning the stage at which we decide whether a non-signatory to an agreement can benefit from it.
Can I stop you there? Can I go
Sure.
back to something you said at the very beginning? Why do we have to write this in a way that applies to all contracts? Why can't we just say, in the area of arbitration, and kind of adopt Meister? Why, you made kind of a broad statement of dogs and cats living together, kind of concept there. Why?
I think that rule would be in danger of being preempted by federal law. So the U.S. Supreme Court in Prima Paint says arbitration agreements are on equal footing with contracts generally. They cannot be more or less enforceable than other types of contracts. That means that you couldn't say, for example, well, we're concerned about arbitration, there's Seventh Amendment jury rights and all of those things, so we're going to have a stricter equitable estoppel standard in this context. That would be, no matter how much we would like that would be preempted. We also think it would be preempted for this court to announce a specific rule that makes it easier to enforce arbitration agreements than other contracts.
Even though they said this is a state law question, then they can say, well, we didn't mean that.
Well, it's a state law question. In Arthur Anderson, the Supreme Court says it's a state law question rooted in traditional common law principles. I think that's ironic because now my friend on the other side is arguing, well, we should ignore the traditional state principles. That's actually precisely what Arthur Anderson, Justice Scalia writing for the court in that case, said that courts should do. They should rely on traditional principles of common law. And that raises, I think, another helpful point, which is useful context here. So some of my friend's arguments seem to suggest a sort of broader concerns about non-signatories to agreements never being able to enforce agreements. I think it's critical for this court to understand that there are plenty of doctrines available for non-signatories to enforce agreements, even if they can't show that they've detrimentally relied on the conduct or statements of a signatory. So, for example, third-party beneficiary theory is one of the most prominent and common examples of non-signatories enforcing agreements. And that doctrine depends on the language of a contract. So to your point, Justice Hood, you asked, well, why does the language of the contract matter? It matters quite a lot. I don't think it matters under the equitable estoppel theory, but it matters quite a lot under the third-party beneficiary theory. That's not an issue before the court here. But absolutely, there are cases that say if the contract, the terms of a contract make clear that the non-signatory is an intended beneficiary, then pursuant to general and traditional principles of common law, the non-signatory may enforce the agreement. Agency and alter ego. So Justice Gabriel, you asked about alter ego. Well, what if there's a claim of alter ego status? Alter ego is a theory that's also available to non-signatories to enforce agreements. But those doctrines aren't before the court here, and the court doesn't need to disturb them or speak to them. The question before the court here is about equitable estoppel. That's a doctrine raised by the defendants in this case. It's a doctrine identified by the Supreme Court in Arthur Anderson. And the defendants now come into this court and suggest that the court should create an alternative theory of equitable estoppel. I think that for the reasons we've argued, that's inappropriate and improperly founded on principles of arbitration the specific to arbitration that should not apply here. There's a suggestion also running through some of the argument on the other side that, that if we don't stop people like my clients from pursuing any of their claims in court, then that's going to leave open the door for some kind of artful pleading, right? So you'd sue non-signatories to contracts and as opposed to the signatories to the contracts. I think that argument is fundamentally flawed. If the concern is that plaintiffs are going to be bringing claims that are not meritorious, courts can dismiss those claims, and they do. But if the concern is that, but if the claims are meritorious, then those claims should be allowed into court and should proceed in court unless there's an arbitration agreement that blocks them. I think that we should be much more concerned in this case about artful corporate structures than we are about artful pleading. Going back to the initial contracting stage here, I query what my clients should have done. Should they have ensured that every party who they were not intending to contract with was explicitly identified in the contract? It's not at all clear what they possibly could have done in order to avoid the suggestion that they would be equitably estopped under this alternative theory. Unless the court has further questions, I'm happy to rest of my briefs. Thank you.
Thank you. Appreciate the arguments of all three counsel. The case will stand submitted, and the court will be in recess until 9 o'clock tomorrow morning.